Hi, welcome back to the podcast, HOA Hell. I'm your host, Michael Kushner, and with me is Senior Associate from MBK Chapman, Sam Kill. Sam, good morning.
Good morning, Mike. How are you?
I'm good, thank you. Hope you had a good weekend.
I did.
So, Sam, as attorneys, we often throw around terms, legal terms that have significant legal meaning that we use every day, and we kind of forget that it's not part of the normal language that regular lay people speak in, okay? Terms like the one we're going to talk about today, which is fiduciary duty. Okay, you and I use that phrase multiple times a day.
True.
It is the nature of what we do, not only as attorneys that focus almost exclusively, or at least focus a large part of our practice on representing homeowners in HOA disputes, but also in our business, in the business aspects of our firm, because we represent multiple corporations. We're corporate counsel. We do business litigation and business transactions, and fiduciary duty is important there too.
Absolutely. 100%.
And we use those terms as part of our natural language without even giving a thought as to what that term sounds like to people that have either never heard the term or have heard it but still don't understand what it is or what it means.
It really becomes automated for us professionally, but I always have to remind myself at consultations to, parse out these operative words.
Right, and the thing is that we have such a deep understanding of what fiduciary duty means down to its specifics that we forget that most people don't. So today we are going to unmask, or we're going to demystify the term fiduciary duty. We're going to talk about what it is, specifically in the context of homeowners associations. We're going to talk about why the fiduciary duty is such an important phrase and why you've probably heard the term before, even if you don't or didn't before this podcast, because you will after. If you didn't understand what it meant, you're going to know. But why that phrase is so often used and why it's so important to you and your rights as a homeowner and your pocketbook. We're going to make sure that you understand the nature of the fiduciary duty that is owed to you by the members of your board and your HOA. And we're going to talk about some of the things you can do if you believe that members of your board are breaching their fiduciary duties to you and to your fellow members. Okay, that's kind of what our goal is today. So let's jump into that. At its core, fiduciary duty means acting for someone else's benefit while putting aside your own personal interests.
Yeah.
Now, that's a very broad definition. It doesn't really impart a lot of information, and I don't think it does a lot to demystifying the term. But that at its core, that's what it is. It's putting the organization, in this case, most of the time a corporation, mutual benefit nonprofit corporation,
the entity,
which is your LLC, putting its needs or what's important to it before your own. But and at its core, that really is what it is. But we're going to go much deeper than that because that doesn't tell you a lot. Okay, it's the highest standard of duty that somebody can impose on someone else. And what I mean by that is there's lots of duties. For example, if you're talking about mere negligence, there's one of the elements to prove a cause of action for negligence is a duty and a breach of a duty.
Right.
But the duty that is being talked about in a case for negligence is orders of magnitude less important than a fiduciary duty, which is why not everybody owes fiduciary duties to other people.
Right.
So in order to kind of bring that home in a couple of minutes, I'm going to talk about, and I think we're going to talk about some of the other aspects of your life where you will, even if you didn't know, where your life is touched by fiduciary duties, so that you can conceptualize the term as something other than this complicated thing that relates to your HOA. So I'm going to bring the real world into it to show you why that's a heightened duty.
Yeah.
But it is a heightened duty. And California courts have long agreed with the legislature in establishing that of all the different kinds of fiduciary duties that exist out there, one of them is from an HOA board and the board members to all the members of the association. Okay? Now, Corporations Code 7231 defines and imposes fiduciary duties of loyalty and care. And those are the two big ones we're going to talk about, a duty of loyalty and a duty of care. Together, that makes up the fiduciary duty that we're talking about. And the corporations code section defines that as saying, look, your organization, in that case, corporation, but it doesn't have to be, because the Davis-Sterling Act has established that any HOA owes duty of care and duty of loyalty as fiduciary duties to the members. So those are two distinct duties, duty of care and duty of loyalty. So we're going to start there, okay? Let's start with duty of care. Talk to me about a duty of care in simple sentence.
Duty of care, especially within the context of common interested developments, HOAs, is the duty to reasonably investigate and exercise due diligence before you act on behalf, in this case, of the membership.
Right.
Yeah, I mean, you've been entrusted with this position as volunteer, board members. You're voted in most cases, and unless you're just filling a gap and you're, being installed to fill a vacancy.
Hence the most cases.
Yeah, exactly. And so you need to exercise, as a fiduciary, as this part of a duty, your utmost diligence in terms of investigating things, relying on information that's at your disposal to make informed decisions.
Right. So, in other words, the duty of care, to put it very simply, is your obligation, fiduciary obligation to the members to do your job with diligent care and in good faith. And what that means is, for example, you follow the advice of the experts retained by the HOA. That doesn't mean that you always have to do exactly everything they say, but you have to, if for example, an attorney is retained by the HOA to look at something and the attorney says, hey, you guys should do X, Y, and Z because the law requires it, or you should not do X, Y, and Z because it's illegal, and you do it anyway, you're violating a fiduciary duty because the expert has told you something. Same with the management company, the accountant, a contractor that's been hired that says, hey, we've got dangerous conditions here. The more serious the issue, the higher the obligation is to listen to somebody.
And by the way, part of the duty also espouses this need to know your limits, the limits of your own knowledge. For instance, if you're not a structural engineer, don't pretend to be one.
Right.
Go seek that advice and knowledge from
them. And as I said, let's say you hear something from somebody and it conflicts with something else you heard. It is no reason why you can't go to get a second opinion.
That's right.
It's not that you have to go lock, stock, and barrel and turn over management of the HOA to some expert. It's that you have to listen and in good faith act on information. If you have a good faith reason to disregard something that somebody has said, then and you can support that, then no problem. Okay? It's just harder to do if you're talking about an expert.
Right.
But there are lawyers that are wrong. So you might say, oh, that doesn't sound right. I don't think this lawyer knows what he's doing. Let's go get another lawyer. And the lawyer gives you a different answer. You can choose to follow that. But that's the duty of care. In very simple terms, you have to act in good faith, you have to act reasonably, and you've got to act diligently. You can't just I'm a volunteer, I don't want to put the time in, I'm just going to do this because I want to. That's not how it works, okay? The second one, and again, there's only two that make up this fiduciary duty, is the duty of loyalty. Duty of loyalty is a little bit more complicated because it brings into account all of the financial aspects of if you're a board member, your obligation. So duty of loyalty would require, for example, that you don't self-deal. What is self-dealing? Well, you have a brother or a son who is a contractor. So you decide to throw all of the construction-related business, for improvement of the common areas to your family member's company without, looking at bids, without taking into account experience and pricing. You just feed your own family's businesses the business of the HOA. That would be self-dealing if the deals that were reached were not on the up and up and were not within the ordinary course. Now, if your family member wants to bid on the project and that person's pricing and experience and everything is competitive, no problem.
Right.
If the other board members are all aware of it and you guys act together, not a problem, unless you're doing it to the exclusion of an open process, okay?
In other words, with an eye towards really benefiting and serving the membership in an HOA and
As
not
opposed to
in a
your
way
family.
advancing your own personal interests.
Exactly.
Yeah.
And or even your company, for example, would be even, I was doing one removed, but let's say it's direct. Let's say you're a member of your HOA and you are a contractor. So all of a sudden you've got all these construction projects to redo all the balconies, $1 million project, and it goes to your company. That would be, in many cases, a huge red flag of self-dealing unless there was a lot of, you went out of your way to really be transparent. And if I were such a board member and I owned a contracting company and I could beat the pricing of anybody else, apples to apples, same scope of work, beat the pricing, I would be very transparent. I would say, hey, membership at an open meeting, I'm bidding my company on this, and I expect to be treated equally and fairly with any other bidder or contractor out there. But if I can beat that person's or that company's pricing, then I'll give myself the job. But I'm letting everybody know that I'm putting my hat in the ring. That would be, and if you ended up being able to be the one that's chosen, that would not necessarily be a violation of your duty of loyalty or self-dealing because you were transparent. Everybody went in with their eyes open.
That's right.
Eyes open, transparency is a good thing. So you can often defeat self-dealing with transparency. But when you do it behind the scenes, you don't share that relationship. Nobody ever finds out that ABC Contracting is really owned by you. That's a problem.
Yeah.
Or if even your other board members don't know, that's a big problem. You were going to add something to that.
I was going to say, that's not merely a thought experiment. As baffling as it seems, we've seen it done the proper way where someone does engage in those disclosures. They make a pitch, essentially, in terms of their own or family member entities to serve and advance the interests of the association, and then they recuse themselves from that board vote and delegate, essentially, or defer to the other board members to take a vote and adopt a resolution as to whether to proceed or not.
Exactly.
And we've also seen it, again, as baffling as it seems, done incorrectly where there's no disclosure, no transparency, and guess what? You see self-dealing in the worst ways. And that's a huge red flag.
So another aspect of duty of loyalty, in addition to no self-dealing, is stuff like no misuse of power. You have to act in the best interest of the community. So you can't act as the bad HOAs that we deal with are HOAs, or one aspect or one type of bad HOA is board members who act as if their HOA is their own fiefdom, that they're some lord of the manor acting in their capacity as a lord of the manor and everybody else is a serf. We see this all the time. It's just not something that is rare. It happens much more frequently than I care to be honest about or care to admit. And the fact is, it's, I guess, part of human nature. But power corrupts, and absolute power corrupts absolutely. And we see that all the time. Or the duty of confidentiality, whether it's confidentiality of attorney-client privilege stuff, what you get as a board member in a board packet and sharing it with your friends in the community, that's a no-no. Or the private disciplinary processes that go on that, hey, you go tell your friend, hey, we were disciplining this loser over here. You can't do that. That is a breach of duty of loyalty that you owe to the other members, including the members that you're disciplining for violation or a purported violation of the rules. Preservation of assets is a big one.
Huge.
Misuse of the funding, of the funds. No, I don't mean embezzlement necessarily, although that would absolutely classify as a breach of fiduciary duty and a breach of the duty of loyalty. I'm talking about you're just careless with the funds. You're not doing the books every month. You're not looking at those numbers. You're obligated. A board member is obligated every month to do a reconciliation. Okay, they might have a bookkeeper helping them, but they've got to go and know it, that the bookkeeper's completing a reconciliation of the whatever checking accounts exist. Maybe an operating account, maybe a reserve account, or there might be multiple. There has to be a reconciliation every single month. Davis Sterling Act requires that. If you're ignoring that, if you as a board member can't answer whether or not your books were balanced, even your checkbook, then you have breached your fiduciary duty.
Yeah.
You better be able to answer that, even if it's we look at the accountant's report every single month and it shows that our books are balanced. That's good enough. But if you can't answer that, you're in breach. It's a minor breach compared to embezzlement, let's say, but it's still a breach of fiduciary duty. And this duty, by the way, lasts even if you're not on the board anymore. It's a continuing duty.
Correct.
Okay? I also want to go back just for a sec. I wanted to give a couple more examples of the duty of care because we really talked about due diligence, but there's a couple more. And I neglected to mention them. So I want to jump back just a minute. I think we covered duty of loyalty.
Yeah.
Now let's jump back to duty of care. Due diligence is kind of a broad language as well. But that means a lot of things. It means following the advice of the experts. It also means attending meetings. Mm-hmm. A lot of HOAs have stuff in their governing documents that says that, if a member of the board misses X amount of meetings, that they can be censured. Or even, that might be subject to opening them up for a recall of some sort, right? You're supposed to be there.
Yeah.
You're supposed to actually attend the meetings, because if you're not doing your job.
Right.
You're literally not governing this HOA. If you're just busy meeting after meeting, if your HOA requires monthly meetings and you're AWOL for 25, 30, 40% of your meetings, you're not governing.
No, you're not.
Okay, you're gone. Mm-hmm. Asking reasonable questions when people are talking, when your expert is talking. You're supposed to engage, not just kind of doodle and not listen. You're supposed to reasonably engage,
right.
Okay? Keeping records accurate and accessible. That means if a 5200 demand is made by a member, that you aren't stonewalling, that you aren't actively standing in the way to prevent disclosure of documents that you're obligated to give up.
Right.
Okay, that is a form of breaching a duty of care. If you're breaking the rules, do as I say, not as I do, and you expect everybody else to follow, I would argue, although it's not probably textbook definition, but I would argue that's a breach of fiduciary duty.
Yeah.
And of course, one of the most important, or we talk about the fundamental requirements of an HOA, right? One of them is maintain, replace.
Duty to investigate and inspect.
Right. Common
especially
areas.
Common area components.
Exactly.
Yeah.
Not doing that as a breach, but also enforcing the governing documents.
That's right.
Against violators is a fiduciary duty. And it's specifically part of the duty of care.
Right.
I would, if you want a quick way to remember the difference between duty of care and duty of loyalty, I would, and this isn't exact in every way, but I think 98% of the time you'll be right, so it's a good shortcut. Duty of care relates to all the non-financial kind of things related to the HOA that a board member is obligated to do. And duty of loyalty is a lot of the financial type stuff, the self-dealing, don't embezzle, be transparent, that sort of thing. So that's a quick way to remember it, although maybe not foolproof. Now, I said I'd give you some examples, and I want to kind of offer some of those examples because there are lots of other aspects where you interplay with fiduciary duty in your daily life. If you're a parent or a babysitter, you have a legal fiduciary duty to the child or children under your care. So let's talk with babysitter. You're a teenage babysitter or a young adult babysitter, and the child you're babysitting goes into some medical emergency, and you sitting on the phone with your girlfriend or boyfriend and kind of ignoring the situation and don't get medical help, you've breached a fiduciary duty. When you have the care of a minor child in your control, that is a fiduciary heightened duty. Parents have a fiduciary duty to their children to feed, clothe, and educate them and keep them safe. That includes getting medical attention for them when they're sick.
That's right.
It includes making sure that they have a place to live if at all reasonably possible. It doesn't mean that homeless people are breaching fiduciary duty because their circumstances are beyond, at that point, they're within the same circumstances. But it would if it was an Oliver Twist type deal where they're eating turkey and stuffing and the kids are eating gruel. That would be a fiduciary breach.
Right.
Okay. So you see that in a parent, you see that in babysitting. Everybody has a fiduciary duty to their children. Attorneys like us.
Yeah.
Tell me about that.
Well, attorneys and clients, we have a fiduciary duty and a duty of care and loyalty, to actually advance, our clients' interests.
So give me the biggies. What does it mean we can't do?
Well, we can't engage in matters that would create a conflict of interest, whether actual or potential.
Without a waiver.
Without a waiver. We have a duty to investigate and do our thorough due diligence.
Let's
on
go
our
back.
matters.
Let's go back to conflict of interest. What does that mean in real life? We can't do what without a waiver?
Well, in real life, to give you an example, the clearest one this comes up most frequently is we can't represent both sides of the aisle, so to speak. So in this case, we can't take on a homeowner client in an HOA and at the same time represent the entity in the board.
That's right. We couldn't take you on as a client.
Yeah.
If we represented your HOA in that matter, or if we represented your HOA in any other matter.
Correct.
we wouldn't be able to take you on as a client and go after that HOA, an existing or former client, without a waiver signed by both sides saying,
full disclosure, all of the details.
we got a problem here. There's a conflict of interest. I'll give you one other example. This happens a lot, and this is between clients, maybe on the same, homeowners, right? Let's say we represent you in a dispute with your HOA, and then we are contacted by another homeowner who wants to go after you for doing something that violated their rights. We wouldn't be able to take that person on as a client.
That's right.
Okay?
Yep.
Now, even if you signed a waiver and they signed a waiver, we still wouldn't do it. Not under that direct conflict, something that easy to see, that abrupt, we wouldn't do it. Because the only way we could get justice for you or justice for them would be to screw the other. Right? So we just wouldn't do it. But technically, if we have a knowing waiver, it is a way to do that. But it's a very bad idea, and most lawyers won't even touch it with a 10-foot pole. But that's an example of attorneys owing a fiduciary duty. And he brought one other thing up, so I'll just mention this one other. Duty of loyalty, that's duty of care, I think. It's both, I think. But another one is when you give a lawyer money that's put into a trust account, we have very, very, very strict fiduciary duty on the disposition of that money, on the accounting of that money. And there are very, very strict rules that are mandated by the state bar on how trust account money is used. That's all part of that fiduciary duty. You see it in trustees of trusts. If you have a family trust, a trustee owes a duty to the beneficiaries of the trust to act in the best interest of the trust. Meaning, let's say you're a trustee of your deceased parents' or deceased brother's trust, and the beneficiaries are, let's say, your nieces and nephews, and there's all this money there. You have a duty to invest that money in good faith and to make sure that it grows and that it's there to accomplish whatever goal was set for the care and welfare of your nieces and nephews. You can't use it to buy houses for yourself or take trips for you and your wife and your family. You'd be breaching your fiduciary duty.
Right.
Another one is guardians and conservators. If you've been named a guardian or conservator for somebody that's incapacitated, in a coma, or has got some mental issue that makes them unable to care for themselves, you have a fiduciary duty to make medical decisions and financial decisions that are in that person's best interest, not your best interest. If that person happens to be very wealthy and you have control of their money, that doesn't mean you can start investing and growing your portfolio. It's not how it works. You got to invest that person and grow that person's portfolio. Okay? Financial advisors, stockbrokers, investment managers, people that you hire to invest your 401k money or your IRAs and all that, they've got fiduciary duties to you. They can't push you into a vehicle that is really high risk and high reward for them based on commission, but that absolutely is dangerous for you. That would be a breach of fiduciary duty unless they told you, look, high risk, high return. This is very high risk, but here's what you get. Now, if you make an informed decision, again, transparency is often the remedy for a claim of breach of fiduciary duty. We were transparent. You made an open-eyed decision. No problem. Okay? But, if I'm a stockbroker, let's say, and I stand to make a double the commission for leading my clients into this thing over here instead of this safer thing, I'm breaching my fiduciary duty. Because what's my goal there? To increase my commission. Right. Not increase my commission and, by the way, get them into what I think is the best investment for them based on all the things I know about there. Now, if I'm dealing with a young person who says, I want you to take a certain amount of my portfolio and go into high-risk stuff, then, okay, you're following marching orders. It doesn't matter if your commissions are higher for those. They typically are. No problem. But part of fiduciary duty is your motivation for acting a certain way is that person's instructions or best interest, not your own. If you ever answer, who's this benefiting? Who's this really, why are you really doing this? Because I was told to, or because I honestly think it's better for that person, or because it's better for me. If the answer is ever it's better for you, you are 100% breaching your fiduciary duty. Okay? If it happens to benefit you, but the answer is it benefits them or you're following their instructions, no problem. Everybody, you're allowed to make a living. Just, it can't be your primary motivation, okay? When in doubt, disclose. When in doubt, be transparent. There you go. Problem solved. And then, of course, you have real estate agents, real estate broker. Same thing. They make commission on properties. Their job is to make sure that they are looking after you, which is why we, as real estate attorneys, in addition to HOA attorneys, we always tell people, almost 9 out of 10 times, don't ever agree to a dual representation where you have the same real estate agent representing the seller and the buyer. I want the person that's looking after me to have his or her bread buttered by me only. Mm-hmm. I never want there to be divided loyalties. It's human nature. You're going to do, in that situation, the person's going to push what's best for him or herself, not necessarily what's best for the clients. Agreed. Never agree on joint rep. Always get your own agent, okay? But they owe a duty to you, okay? They have a duty to make sure that that they are disclosing all the things that they know when they're trying to get you into a property. Not, I want to close this because I've shown you 40 properties and you haven't purchased yet and I'm done. I want you to do this, close the deal so I can get my commission. That's a breach of fiduciary duty, okay? They have to do what's best for you. And then there's partner and a partnership, corporate officers and directors, executive and administrators, real estate. We just talked about pension fund managers, all that sort of thing. So those are the different kinds of fiduciary duties that you guys run into in all of your everyday lives, right? Okay, so we've talked a lot about and given good examples, I think, about what fiduciary duties are. Mm-hmm. We talked about duty of care and duty of loyalty. We talked about examples of duty of loyalty. And let me give you some examples. Now, we talked about how you could breach your duty of care. Here are some of the ways you could breach your duty of loyalty, right? Mm-hmm. Embezzlement. Yeah. Easy peasy. That's an easy one. Yep. Ignoring reserve studies. Right. Manipulating reserve studies. Go watch our 2-part reserve study podcast. Mm-hmm. Okay. Ignoring reasonable advice from professionals hired to help with the financials of the corporation. That's both. Right. Okay. Mm-hmm. Steering contracts to family and friends. We talked about that one. Yeah. Failing to address obvious maintenance, safety issues. Failing to maintain, to repair and replace common areas. Those are all breach of duty of loyalty and duty of care. Some things can be both, and therefore breaches of fiduciary duty. Right. Now, these are not abstract principles. They're pretty easy to identify once you know what to look for. So let's talk about what to do once you recognize it, because now you kind of know what it is. You know what to look for. For example, easy case, you find out that, and you find this out not because it was told to you, which would have been the way to do it, but because you happen to find out somehow, that there's a bunch of work that's going to be done to the common area, and the contract went to a director's own company or to a family member's company. You find that out. That's a big red flag of a fiduciary breach. Now, it might later turn out that it was in the minutes and you just didn't look at them, or you weren't at that meeting, or that it was a blind bid. He put his company up. He told everybody on the board, hey, I'm going to put it up there, but he was the best bid, and you can go and look at them through a 5200 demand. You could find out. It could be that, but it's typically not that. No. Okay? Because if it were me again, I would make sure everybody in the HOA knew it. Then I could never be accused. Okay? So what do you look for, and what can homeowners do, okay, when they think board members are breaching fiduciary duties? Okay? What's one of the, and this is our mantra, other than review your governing documents, which just doesn't apply here. What is one of the things, and I'll give you a hint, 5200. What is one of the things that a homeowner who has a suspicion that there's some fiduciary shenanigans going on can do to find out if such things are happening?
Well, serve your HOA Civil Code Section 5200 documents and records request, and specifically look into the contracts, financials, and you alluded to this earlier when it comes to disclosure and whether there was a board resolution, for instance, on contracts, bidding, etc.
And disclosure of personal
request minutes. Right, minutes and probe into that.
Yeah. So request. You said request financials. You can get every checkbook of every account, every bank statement of every account, unredacted, canceled checks, profit and loss statements monthly, right? Reconciled profit and loss statements. Those are all. If you go to the article on my website, under the libraries tab, go to articles or even fact sheets, you'll see a list of all the documents you're entitled to. And the code sections, and we have a podcast on that episode as well. We do. On that, and we go through the same stuff in that episode. It's all over the place if you come to us. So you'll be able to, you're entitled to a whole bunch of stuff that will help you determine minutes for the open meetings. You're not going to get the minutes for executive session, but you'll get the agendas, find out if it was an agendized item. Yeah. they have to, and the minutes of the open meeting have to generally discuss what was talked about in the executive session. So although the minutes of the executive session might say we had a hearing on the discipline of Bob Smith for doing XYZ, the open meeting minutes might say we had some discipline hearings of some members.
Right.
But at least you'll hear that. Or we discussed a contract to look for a contractor.
Right.
That sort of thing. Look for that in the open minutes. Look for the agenda on the executive session, discussing contracts or discussing hiring a contractor to do the balcony repairs.
And that really should not be confidential or privileged.
There's no such thing as that.
Yeah.
If you hear that, again, go to our show.
Red flag.
That's another red flag. Point is, there's a lot of documents you can ask for.
Yeah.
So financials, minutes, contract, copy of, I want to see every bid and every contract submitted by a contractor for this project in the last year, whatever it is. You're entitled to all of it. Okay. Another one is you could, and this is one of those examples where I don't think IDR would ever be helpful, but if that's what you want to do, you can try IDR. You're entitled to that. But I would, this is where you'd come to counsel like us at MBK Chapman and have us prepare a formal Davis-Sterling Act ADR demand and drag your HOA to ADR, or at least give them the opportunity. Now, 99% of the time they accept because they know the consequences for not doing that. But I would, under 5930 of the Civil Code, I would do an ADR demand. Okay. Another one is if none of that works, if you can't resolve it at ADR and you weren't able to resolve it at IDR if you went that direction before contacting us, then litigate. Okay. Because what you can't do is just ignore it. If you've satisfied yourself that there is fiduciary breaches occurring, or it's obvious and you didn't have to even get documents, you can see what's happening, then at that point, that's a serious issue that needs to be addressed immediately. You don't want to sit on that because depending on how serious the breach of fiduciary duty that we're discussing is, it could very quickly devolve into financial disaster or health and safety disaster, depending on the nature of the issue.
Sure.
Sam, in general, anything else on fiduciary duty that you don't think we talked about that would help clarify? If we did a great job, tell me and we're good.
I think we covered it pretty adequately for our purposes today. And I think the interplay between this episode and some of the other ones that you refer to in terms of the 5200 and some of the reserves, and I mean, all of this kind of fits together.
Of course.
And so
we've got one on selective enforcement and on reserve studies and on management companies. And remember that one on management companies where you have board members delegating non-delegable duties? All of that, breach of fiduciary duty.
That's exactly it, yeah. So I think that was pretty good in my view.
Yeah. Basically, I think what Sam was alluding to here is that breach of fiduciary duty touches every aspect of misconduct by a board.
It really does. It
can.
Yeah.
It can. And so every episode, to the extent that our episodes are based on helping you make bad HOA boards good HOA boards, almost every episode we do has to do with fiduciary duty.
Right.
Which is why a lot of this might seem familiar, but you just didn't know what term or phrase to use to couch it. Now you do. So, in I guess as a closing thought, I might say this. A breach of fiduciary duty is a very broad term. I started out by saying that. It encompasses a very broad set of duties, two of them, a duty of care and a duty of loyalty. Every board member owes a duty of care and loyalty to every one of us, regular members of the HOA, and to the HOA itself as an entity. And when they breach that duty, it's always serious. Sometimes it's much more serious than other times. There's a gradation of seriousness, just like there is with everything, but it's always serious. And it can, and most often, almost always does, affect your pocketbook and your quality of life at your specific HOA. Because when HOA boards are violating their fiduciary duties, they're breaching fiduciary duties, your HOA is automatically a bad HOA. It falls into the bad HOA category. And that is something that you cannot tolerate. If there's anything you can do, you must do it. Because it will eventually come back and bite you, either because of selective enforcement, unfair treatment, special assessments, mismanagement, massive waste of assets, self-dealing, embezzlement. We have an episode on embezzlement. A whole host of really bad things happen when you have board members that don't care, or board members that are acting in their own best interest and not in your interest.
Yeah.
Okay. Other than that, I think Sam's right. I think we covered it. If you have any questions or you want to leave any comments regarding this episode, we'd love to hear from you. If you like this episode, please do hit the like button. It matters to us. And please subscribe to the channel, HOA Hell, if you haven't already done so. Until next time, have a wonderful day.